Good morning, Mr. Sager. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Essentially, you and the state have not been able to work out an agreement, so you're coming to me for punishment for purposes of this case that you want to end today. Is that right? You need to understand that you give up a lot of rights by entering into this agreement. You're facing 180 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged with in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeals. So whatever happens today happens, and that's it. There's no turning around and trying to change your mind. Do you understand?
Yes, sir.
Now, I'm a firm believer that everybody deserves a chance, really. But the problem is we have people that we give them chances and they take the chance, but then it continues to happen over and over and over. And that's what we are trying to prevent from happening with you, Mr. Sager. You know, we all make mistakes, but the problem is that when you make a mistake where you're in danger of someone's life, you have to take notice. And when you don't, and when it continues to happen, if it continues to happen, the sentences get longer. The costs become bigger, especially with the DWI. Now you're facing, like I said, the 6 months. Your lawyer's asking me to set you for a deferred, which is a type of probation that if you complete, you do not end up with a conviction on your record. I will do this for you today. I will set you on a 1-year deferred. I'm going to sentence you to 180 days in jail, and I will not find you guilty, and I will put you on this deferred for a year. However, you will be required to satisfy conditions. If you do, fantastic, you will not end up with a conviction on your record. But you need to understand something. For all intents and purposes, if you're pulled over, an officer's going to see this. They're not going to give a rat's behind whether it's a deferred, whether it's a conviction, whether it's a dismissal. If they see that you have a prior DWI and they smell alcohol on you, it's probably not going to go well for you. Do you understand?
Yes, sir.
So what I'm trying to say is that even if you have half a beer, a sip of something, don't get into a car because it's a huge risk. Do you understand?
Yes, sir.
So it is a 180-day 1-year deferred. You will maintain a guardian interlock while you're on this deferred. You will do a DWI education class, a victim impact panel. Do you have children? We will do a parenting class in lieu of community service.
Sure.
No drugs, alcohol. You will do what's called a TRAS, to see if you need other conditions. If they assess other conditions, you must fulfill those conditions. No breath test refusal, meaning that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it while you're on this probation. If you don't, you're in violation. If you violate this probation, I will issue a warrant for your arrest. We will have a hearing to see if you violated this. And as you see all the people that came out, you're going to be dressed in orange. We're going to bring you back out. We're going to have a hearing to see if you violated. If you do, or if you did, you're looking at 180 days. Do you understand?
Yes, sir.
Do you mind running his license to see if it's eligible, please?
Yes, Your Honor.
I didn't forget anything, did I? That's about it. So the only other thing I'd like to know now is whether your license is eligible or not. Because if it's not eligible, I'm going to order you not to drive and we'll give you a portable device. You're not allowed to drive unless you have a valid license and liability insurance in your name. You must maintain car insurance while you're on this probation. You must give them proof so that we know that you're driving legally.
It's eligible.
Wonderful. Okay. I'm not going to suspend your license now, so you can continue to drive, but you must get an interlock within 7 days. Do you understand?
7 days?
Correct. Yeah. Do you have any questions?
No, sir, not at this time.
The only other thing that I'm going to impart to you now is that DWI is huge business in Texas. There is a $3,000 surcharge. Is this a 0.15 or above? It is.
It is, yes, Your Honor.
All right. Is it true or untrue that you had a 0.15 or above? Oh, well, I guess you didn't. It's not pled as such, right? Okay. So the reason I'm trying to tell you is that there's a $3,000 surcharge that tags onto you when you pick up one of these types of cases. I'm going to waive it for you now, but on a second DWI, it's a $6,000 $1,000 surcharge. And if you don't pay it, every $100 you owe, you sit 1 day in jail. And I routinely put it on seconds. So beware, it's going to cost you a pretty penny. You pick up another one, not to mention a minimum of 30 days. Well, there's no minimum because deferred. Do you understand?
Yes, sir.
All right. Good luck to you, sir. Thanks. All right. Good morning, Mr.
Good
McCann.
morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said that defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you see?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time and the defendant was aware. So this baby refiled as a felony. I'm not sure yet, but sort of that right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those, violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it was the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parham. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with police for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
there
there
is.
is. Bond said, Judge, with regards to the bond condition, I was wondering if we could amend those or have them reflect the no threat and harassing communication instead of no contact. They do.
They haven't been able to reach her.
They haven't, but the DA hasn't, but that she has spoke with her back. And she had spoken to the back and told her that she did want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant,
no, she's already had the child. They already have a child now. That's the only reason why I say now.
Yeah, this did happen back in June.
They do have a
If,
child.
well, let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, and if you could, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm gonna order it. If she does, then we can revisit it at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I got to go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right, thanks, guys.
Judge.
This way. What was the last name on this one?
Callahan.
Okay, thank
Good morning, Mr. Callahan.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 6 days in jail, credit for the 2 days that you've done. This is a plea. It's a plea of guilty. You need to understand this charge will go on your record. It's going to be there for the rest of your life. It's even there after you die. It's important because if you get pulled over, officers see this, they come up to your car, they smell alcohol, it's probably not going to go well for you. And what we're doing today, time served, you're facing a minimum of 30 days in jail after today. Do you understand? It's a true first.
Double check. I believe it is your honor, but.
Um,
I'm running real.
The other thing that you need to understand is that DWI is extremely big business in Texas, meaning that there's a $3,000 surcharge that tacks onto you when you have a case like this. And if you don't pay it, you sit 1 day in jail for every $100 you owe. We all make mistakes, and I'm going to waive that for you today. But if you continue to make the same mistakes where you endanger other people's lives, it just gets so much worse. A second DWI, $6,000 surcharge. Do you understand? All right. We all make mistakes. Just don't make another one. You know what I mean? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, there's no turning back. It's going to go on your record. Is this what you want to do? All right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I also have to suspend your license. I will suspend it for the minimum, which is 90 days. Do not drive until you get a license. Good luck to you, sir. All right. Please see the clerk. That way.
Yes, sir.